breakthroughs through his interventions. The complainants were either recruited to go to Durban by their local pastors or Fezeka, or accused 2 and accused 3, after accused 1 displayed an interest in them. All the complainants became members of the church and went to Umhlanga, where they stayed in the mission house to develop their music skills, to prayer and healing. Some went there to complete their education or to further their studies. Their transport costs to Umhlanga were paid, and transport was arranged by Fezeka or their local pastor, or accused 2 and 3. Accused 1 is a self-taught musician playing different instruments he used in accompanying the choirs. He considered himself a prophet, and he was seen as one by his congregation members. He professed to heal the sick and to perform miracles. Testimony was given that if one of the pastors died, he would tell the congregants that it was because the deceased had not listened to him. The JDI has branches in all 9 provinces of the country. The headquarters of the JDI is in Durban, with a mission house in Umhlanga. The church holds crusades in different centers of the country, which crusades are attended by the members who come from all branches and regions to attend such crusades. Sometimes accused 1 preached live from Durban on televised services. At services, the so-called miracles accused 1 performed were shown on TV screens. All the complainants were members or attended services in the different branches, and in this way were persuaded to join the GDI. Once a complainant is introduced to accused 1 or given his cell phone number, she is required to send and text messages to him regularly. The complainants were given money or sent money to enable them to go to Umhlanga by bus, or in exceptional circumstances to fly there. The complainants largely became members of singing groups, the Grace Galaxy or the Chrysalids, that performed at the crusades and travelled with the accused to various centres. At the mission house, the complainants stayed in groups in different rooms, and there were at times approximately 25 girls in the mission house. There they engaged in music and singing practice, prayer sessions, they played games and had individual appointments with accused 1. According to the complainants, they were then individually summoned to his room by one of his personal assistants after being ordered to shower and clean themselves. In his room, they were ordered to close the door, and there they kneeled before him where he sat on the bed. They were then to massage his feet. The issues in the trial largely centered on what happened inside the room of accused 1 in the mission house and at the other centers where they attended crusades. It is common cause that the complainants massaged his feet. According to the complainants, it is generally during these appointments when he sexually assaulted them or raped them after coaxing them onto his bed. After the sexual assault, he ordered them to his bathroom to clean themselves. These scenes repeated themselves, and some of the complainants were repeatedly sexually assaulted or raped. It is a recurring theme that some left the mission house but returned on their own volition. The history of this trial. This trial commenced before me in July 2019. After initial applications for further particulars and an objection to the jurisdiction were dismissed, as well as the applications to appeal against those orders were dismissed, the state commenced with the leading of evidence. It then became apparent that the evidence was not in line with the indictment. It is appropriate to mention at this stage that Mr. Ntelwa, who was the lead prosecutor at the time, assured me that he had consulted with all the witnesses, for it seemed that he was not au fait with their evidence. He initially indicated that he was not going to apply for an amendment of the indictment, but he did bring such an application. Some of the amendments were granted, but others were dismissed. It later transpired that the indictment served on the accused was not the same indictment that they were asked to plead to. This second indictment incorporates some of the amendments that was the subject matter of the application to amend. I was informed at one stage that Mr. Ntelwa was being replaced as the main prosecutor, and the matter was postponed, enabling another prosecutor to come up to speed. However, Mr. Ntelwa was placed on record again and continued leading the evidence of the respective witnesses. However, when Ms. Gianni testified, he did not lead her evidence, and another prosecutor did so. During her evidence, where she testified about the events that gave rise to the charges against the accused, it became apparent that she deviated from her version as told to the expert, Professor Miller, and the second indictment. Thereafter, Ms. Serfontein, who was previously in the prosecuting team but had withdrawn, disclosed to Mr. Doberman, who appears on behalf of the accused, that Ms. Gianni, during consultation, averred that the first accused put his finger into her vagina and thereby raped her. This precipitated an application to call Ms. Serfontein as a witness. This application was refused. Thereafter, due to certain facts that had been disclosed, an application for a mistrial was lodged, wherein voluminous affidavits were filed. The application was dismissed, but I ordered that the prosecutor, Mr. Ntelwa, be replaced. After the trial recommenced, the cross-examination of Ms. Gianni continued and their evidence was finalized. Just one further witness testified after that. During the trial and before finalization of the state case, a further application was brought for special entries in terms of Section 317 of the CPA. At a previous junction in the case, an application was also brought for special entries to be made. The state and the defense agreed to the following special entries. A. On 3 July 2019, the lead prosecutor in the case, Advocate Nkeba Ntelwa, proposed to his supervisor, Advocate Gowden, and his junior in the case, Advocate Serfontein, in an email which he sent to them that certain witnesses, namely Ms. Gianni, Ms. Msibi, and Ms. Mafike, be suborned to commit perjury. Advocate Ntelwa, Advocate Serfontein, Advocate Makasana, and Advocate Babulwa, full prosecutors in the case, intentionally failed to disclose to the court and or the defense that Ms. Gianni had made a previous inconsistent statement to Advocate Serfontein to the effect that the first accused had inserted his fingers into her vagina. Advocate Ntelwa's superiors, Advocate Gobadon and Advocate Gowden, allowed Advocate Ntelwa to continue to prosecute the accused in the knowledge that Advocate Ntelwa had made the proposal referred to in paragraph A above. After an application in terms of the provisions of Section 174 of the CPA, 31 of the charges were dismissed as no evidence was led in respect of those charges. Furthermore, in respect of 2 other counts, I found that the witness Ms. Gianni's evidence could not be relied on, and those charges were dismissed as well. 11 complainants testified on behalf of the state, as well as 2 expert witnesses. After the application in terms of Section 174 was partly dismissed, a further application was brought to have the evidence of the complainants ruled inadmissible. This application was also dismissed. All the accused testified in their own defense in respect of the remaining charges. The state case. It is a recurring theme that the girls would be called for an appointment at the mission house with accused 1 in his bedroom by either Fazeka, accused 2, or accused 3. It was during these appointments that accused 1 sexually assaulted them or raped them. The evidence was that when these assaults occurred, accused 1 would tell them to lie on the bed after fetching a towel from his bathroom. He would lie on top of them with the lower part of his body naked and hump them, as they described it, until he ejaculated. Then he would send them to his bathroom to clean themselves and send them out of the room after praying and asking for God's forgiveness as they have sinned. The complainants realized that the appointments they were called to was an euphemism for sex with accused number 1. The witnesses that testified are Andiswe Diki, who was 30 years old and resided in East London. She joined JDI in 2014 after she returned from Cape Town on her mother's insistence as she struggled with an alcohol addiction. She had seen videos of accused 1 where he healed people. One such video was about a child that was born without an esophagus who was miraculously healed after accused 1 prayed for him. This video was played at church services, and many of the other complainants testified about this video as well. Ms. Diki started a business baking and selling cakes, muffins and bunny chows. She attended crusades and other centers, and in 2015 at a crusade in East London she acted as an usher. She was standing at the back of the church when accused 1 walked towards her. He spoke to her and gave her his telephone number. Thereafter, accused 2 and 3 took the complainant's cell phone number, and accused 3 told her that accused 1 liked her and that she will contact the complainant later. At another crusade, accused 3 told her to go and greet accused 1. She complied, and accused 1 shouted at her for not texting him. He told her that her destiny is at the mission house in Durban, and she should never offend him because he was God's favorite child, and that she must be obedient to accused 1 when she arrives at the mission house. She went to Durban after receiving money from the accused, and upon arrival at the house she was shown a room where 6 other girls also stayed. She was taken to the bedroom of accused 1, and he said that there were girls inside the house that were satisfying themselves sexually with a shower, but it will never be the same as this, while pointing to his penis. In the lounge, she saw accused 1 touching the girls' breasts, backsides, and lifting their skirts. She was shocked and scared. Later that evening, she was called to his room, where he took her on his bed, and the previous scene as set out earlier played out, and he gratified himself until he ejaculated. He then said a prayer: Lord, forgive us, wash us with the blood of Jesus, write our names in the book of life. She stayed at the mission house for a period of about 13 months, where he sexually assaulted her repeatedly. The complainant and the other girls were instructed to undergo HIV tests, and the results were given to accused 2. Lerato Masidi testified that at the time of her joining JDI in 2012, she had a heart condition and was homeless. Her pastor arranged and financed her trip to Durban to attend a crusade. At another crusade in Secunda, Presenter ordered her to go into a motor vehicle. Accused 1 was inside the vehicle with 2 members of the Grace Galaxy Choir. They went to a hotel in Sandton where accused 1, later in the evening, in his room, instructed her to take off her panty. She was scared and shaking, and accused 1 told her to relax, and he dismissed her from his room. She was later instructed to attend a crusade in Durban and was sent money to go there. At the mission house, she was instructed to go for an appointment with accused 1. There she had to massage his feet, and the same scenario followed as set out previously with the sexual assault. After accused 1 ejaculated, he placed his hand on her forehead and prayed, forgive our sins, we have sinned. Masidi stayed at the mission house for 3 weeks, and after every appointment he would recite the same prayer. Masidi went to the different mission houses from 2012 until 2016, where sexual assaults happened regularly. After an incident where a girl was pregnant and she took her to see accused 1, and the girl came back crying, she decided to expose accused 1 and attempted to lay a charge with the police. She also contacted other girls that had been at the mission house. The police advised her to go back to the church to resolve the issue. One of the other girls later contacted her to say that she has successfully laid a charge, and the police will contact her. The twin sisters, Anele and Liswa Makaza, were participants in the South African singing competition Idols. They wished to join Grace Galaxy Choir but were rejected due to their age of 17 years. Later, another member of the choir contacted them, and thereafter Fizeka called them and informed them that they are part of the Grace Galaxy. They were told that they had to go to the mission house in Umhlanga to rehearse with the group. They were still attending school, and accused one paid their school fees. They were in the same way individually called to an appointment where they were sexually assaulted. After the sexual assault, the accused one prayed, "God have mercy on us." This happened more than once to each of them. When I went to accuse one to tell him that they intended to leave the mission house, he cursed them and told them that their body parts will be scattered all over and dogs will drink their blood in the streets. He also said that one of the sisters will get pregnant and both will marry the same man. What distinguishes their evidence is that after accused one's arrest, they were at the front of a group of young girls protesting his innocence that was broadcast on television. They testified that it was because accused two told them always to protect accused one. Neliswa came forward and reported the abuse as she could not live with the guilt anymore. Gloria Rejoice Mwakaza, the mother of the twins, testified that she knew all the accused from the JDI church. Rizeka came to her and asked her to send the twins to accused one to be trained in music. She refused to do so. However, the twins begged her to go, and eventually they went. They were supposed to return as they were still attending school. She was not allowed to see her children, and when she saw the children at church, they ran away when accused one appeared. She went to report the matter to a brigadier in the South African Police Service. He told her that there is nothing they could do about it. She had seen that the police feared accused number one, for in church they went so far as to take off their uniforms and lay it on the floor so that accused one could walk on it. She found accused one's number and phoned him and told him to let her children come home. He called her stupid and ungrateful, but the next day the twins came home. Shlubekazi Vicky Faleni joined JDI in 2009 in East London. In 2013, a flight was booked for her to go to Durban for an audition for Grace Galaxy. The first night she was there, she was called to accused one's room by Fizeka. Accused one told her to lock the door, and he asked, and she did so. He asked her what she wanted him to be. He was dissatisfied when she replied, "A father figure," and he said he's not there to play father. When she responded, "mentor," he said he does not like slow people and she can be his girlfriend. When she reiterated that she wanted him to be a father figure, he instructed her to call Fizeka. The latter told her accused does not want to be a father figure, and she was listening to him. She went back to his room, and the sexual assault by accused one followed the same pattern as previously set out. Afterwards, he prayed, "God have mercy on us." The accused told her to move to Durban permanently as he will pay for her studies. She did so in December 2013. When she refused to go for appointments to his room, he would curse her and he told her she would die. The sexual assaults and oral sex she had to perform happened regularly, and he would pray after such sessions. When she refused to go for further appointments, accused chased her away in December 2014. Sarah Nompela Mafikeng became a member of JDI in 2012 when she was 17 years old. In December 2013, she met accused one. After she received the matriculation results in January 2014, a pastor asked her if she wanted to share a testimony about the said results in Durban. Shortly afterwards, she received a call from accused one, during which he asked her if she had a boyfriend, and he told her he will be her boyfriend. After sending him photos of herself at his request, she received a call from Fizeka. She sent her money and she went to Durban by bus. When she arrived at the mission house, she was taken to accused one's room. He asked her what she wanted and said she wanted to further her studies as she was an orphan and lived with her grandparents. He said she was in good hands and she went back to her room. That night at about 2 a.m., Fezeka woke her and took her to accused one's room. When he wanted her to take off her panties, she lied and said she was menstruating. The accused became angry and called Fezeka, who said that she made God angry. Fezeka said she must apologize, which she did. She was given money to go home to Secunda. A few days later, she received money again and was told that she must return to Durban. On her return, accused one told her she must be obedient if she wants to survive. God had shown him that she was going into business and not study further. At the time, there was an article in the newspaper where the mother of the twins alleged that the accused one had kidnapped her children. For a period of 3 weeks, all the girls and accused one stayed in a hotel, and afterwards they all moved to a house in Royal Palms in Umhlanga. There she was summoned to accused one's room by Fezeka. She was sexually assaulted by accused one. Afterwards he prayed, God forgive our sins, wash us with the blood of Jesus, be with us in Jesus' name. Thereafter the sexual assaults occurred regularly and he also instructed her to have oral sex. She testified how the congregants, which included police officials, idolized accused one. She was contacted by Ms. Gianni regarding a program that was broadcast about accused one on special assignment. Zandile Matibe was 25 when she testified in 2021. She was a member of JDI from 2011 until 2016. In 2012, her pastor told her that there was an opening in Grace Galaxy and she must phone accused one. She sent him an SMS and he called her. He wanted to know if she knew anyone in the mission house, and she said Gianni. The latter phoned her and said accused one. She said she must send photos of herself. She did so. Accused one phoned her and told her he wanted her to come to Durban. Her mother refused as she was in grade 12 and attending school. In August 2012, she attended a crusade in Durban after she informed accused one that she wanted to go. She travelled to Durban with a church transport after Fezeka sent her money. After the church service, she went to the mission house on instructions of Fezeka. She slept in her room with Fezeka, saw accused one, but went home after the weekend without incident. In December 2012, she attended a 2-week-long service in Durban, and she travelled with 5 other girls. After the service, she went to the mission house, and there were approximately 30 girls there. She slept in an outside room with 10 other girls. She was called to his room where he got on top of her while she was clothed, as she stopped him from removing her pajamas. He ejaculated and afterwards prayed for mercy and God to forgive them. After a week, she went home without further incident. She went to Durban twice after that. She went to the mission house in August 2013. She was called to his room where he asked her if she had a boyfriend and what she wanted from him. She said she needed a mentor and a father. He then told her that he can see she was not serious. Thereafter, he ordered her onto the bed and followed the same routine as set out previously until he ejaculated. In August 2014, she was again called to the mission house. She and another girl went to accused rooms after they were called. They indicated to him that they wanted to go home the following day. The next day, he preached in church that people who leave him will die. She and the other girl became scared and stayed for a further 3 weeks. During Easter 2016, she travelled from Secunda to Durban. At the mission house, accused one told her she had penis written all over her face. She left after 2 days. She feared accused one for what he predicts does happen and is able to perform miracles, she thought. Dolly Fuyuseka Nondlazi was 26 at the time. She testified in 2023. In 2009, when she was 12, she attended JDI with her stepmother. She joined the church choir, Hosanna Voices, and she knew accused one as the person who leads the Grace Galaxy group. She attended a crusade at the Motherwell Sports Centre where someone told her that accused one wanted to see her. She went to him and he asked her whose child she was. She called her stepmother, and the accused one told her stepmother that he wanted to take over the complainant's life. The stepmother agreed. She was still in grade 10 and did not have a cell phone, after which accused one gave her 1,000 rand to buy a cell phone. She sent the SMS to thank him from the new cell phone. She sent him SMSs on a regular basis and told him everything she was doing. She was called to a crusade in Cape Town, where the accused one asked her, how close does she want to be to him? She said she wanted him to be her spiritual father. Accused one told her she must go and think about her answer and dismissed her. She did not send him messages and did not call him. He called her at 3 a.m. and shouted at her that she is misbehaving, busy with boys, not listening to him and not cooperating. Fizeka booked a flight for her to Bloemfontein as there was going to be a crusade there. She was taken to accused one's hotel room where he sexually assaulted her. In the lounge of the hotel afterwards, accused one told Fizeka she is fire, fire. She realized that she was taking the man of God in the wrong way. In 2009, she was in grade 11, and there was a crusade in Kobega. As she walked, accused one's car stopped and he instructed her to get in. He asked her to move to Durban, and he promised to pay for her schooling. She asked her biological mother's permission, and thereafter Fizeka told her that she's booking a flight to Durban. In Durban, she was taken to the house where accused one stayed with other girls. Fizeka told her to wash and took her to accused's room. There, accused instructed her to take off her clothes, and he sexually assaulted her after he told her that she is his girlfriend now and is fire, fire. The group Galaxy was formed and she was one of the members. They moved into a different house where accused one also came to stay. He continued his sexual assault every night. She accompanied accused one to Nigeria to attend a crusade. She was called to his room one night where she had to perform oral sex, and thereafter he sexually assaulted her as well. They flew back to South Africa. Dolly Nonglasi also accused one to Israel in 2013 and 2014. He told her and the other church members that were accompanying him that they can see the life he is introducing them to if they were to stick with him. After the church service, she was called to the room of accused one, where he again sexually assaulted her. On their return to South Africa, she was diagnosed with tuberculosis and admitted to hospital. When she was discharged, about 3 to 4 weeks later, accused one told her that she must return to Kobega. He called her again and they left for Nigeria with the twins and Vicky Faleni, where they recorded a music video before they returned to South Africa. Back in South Africa, accused one verbally abused her. In 2015, the girls decided as a group that they wanted to go and tell him they wanted to go home. They did so, and at a night vigil that evening, he called them to the front and told the congregation that they are ungrateful and they will never get better, and he will see where they ended up. They left by bus that night. In 2015, the complainant relocated to Cape Town. She was called by accused 2, but told her that accused 1 said she must go back to Durban. In 2018, Fizeka called her and told her that there's a journalist asking questions and she should not divulge what happened in Durban. Cheryl Zondi had testified in a trial that had commenced before Makahula J before he recused himself. She joined the JDI in 2009 when she was 13 years old. Initially, she was a member of another church, but she attended the service of the JDI. At this service, the video of the boy born without an esophagus and was healed by accused number 1 was shown. This, as well as other videos of accused 1, impressed her so that she joined JDI as a member. She went to a crusade in Durban, where she saw accused 1 surrounded by beautiful girls and saw the chrysalids sing. She decided she also wanted to be like that. Accused 1 accompanied the singers on a keyboard, and the pastor said anyone who wanted to sing must put their names down. She had been singing from the age of 3 and put her name down. After she sang, the pastor told her that accused 1 really liked her. Tracy, one of the beautiful girls, gave her accused 1's telephone number and said that she must phone accused daily. She did so and told him everything she was doing. She felt that she was chosen by God in 2010, she was invited to Durban, where accused 1 was going to train singers. When she told accused 1 she was coming, he said she can come and stay at his house. After the service, Fazeka told her that accused 1 was waiting for her, and so when she got outside, he was waiting in his Lexus. They went to the mission house. She was called to his room and he wanted to get on the bed with him. He asked her about her love life and how close she wanted him to be. She could sense that the answer she gave was not what he wanted, and he told her to go. She was again called to his room. There he masturbated and was on top of her with a naked lower body. She could feel his penis on her clitoris and entering her vaginal opening slightly. After ejaculating, he told her to go wipe herself and get back into bed. He fell asleep on top of her. When he woke up, he rolled off and started praying, God have mercy on us, for we have sinned. After instructing her to get dressed, he told her what had happened between them was a covenant between them and God, and she should not tell anyone. If she broke the covenant, the punishment will be death. He asked her again how old she was, and she told him she was 14. He said the man of God cannot go to jail, and she assured him that she will not tell anyone. She also went to Nigeria and Israel with accused number 1. She was repeatedly sexually molested on those trips. 2 experts testified on behalf of the state, Professor Carden Miller and Carden Hollerley. It was not an issue that they were in fact experts. Dr. Miller is a leading international expert on crimes of sexual and gender-based violence against children and other vulnerable groups. Carden Hollerley has been working with the Child Witness Institute for 25 years in cases of violence against children specifically and other vulnerable groups, and disclosure processes and reasons for delay in reporting. They interviewed the complainants and found that accused 1 manipulated the complainants by fear and threats. He continuously asked them what they wanted from him, while he knew they wanted to be close as he professed to be a man of God. In this way, he made them complicit in his predatory behavior. He made them believe that he had direct contact with God and had unlimited power. The defense case. The first accused confirmed that he is the founding president of the JDI. The church has mission houses that are places where religious activities occur. For example, prayer sessions, music rehearsals, and biblical
brought into sharp focus questions around the nature of the cross-examination that typically takes place inside courtrooms, especially for victims of sexual violence. I mean, there were some really graphic details in the line of questioning, I remember, that really sparked all manner of debates about the appropriateness of that kind of questioning. We'll try to re-establish that connection for you. Timothy Omotoso, of course, is accused of rape, human trafficking and abuse during his time as leader of his church. He, of course, has been in custody since for about 8 years. So if my maths is anything to go by, that's around 2018, 2017 or so, while his two co-accused have been out on bail since this matter reached the court. It's a seminal moment for many of the victims who are, without a doubt, watching closely what will happen next, given just the many stops and starts in this particular trial, with recusals along the way, and of course the kind of testimony that needed to be provided once again, which in some instances is said to have re-traumatized some of these alleged victims. We'll try to re-establish that connection for you in just a moment to get you a sense of where all of this will lead. But for now, perhaps it's worth
the trial. The following matters can be used as examples. An indictment was served on the accused which started the proceedings against them. The indictment that the accused were required to plead to, the second indictment, differed from the indictment served without informing the court or the defense of this fact. This only became apparent at a later stage of the proceedings. Ms. Serfontein, one of the initial prosecutors in the case, consulted with some of the witnesses. She established that the witnesses' police statements differed from their versions during consultation or differed from the indictment. She advised Mr. Ntelwa, the lead prosecutor in the case, Advocate Gobadon and Advocate Gownden, of the discrepancies. Instead of obtaining the correct version by way of written affidavits, Mr. Ntelwa wrote in an email that the witnesses should be persuaded to stick to their versions as set out in the police statements to prevent a possible postponement. Ms. Serfontein brought this email to the notice of Advocates Gobadon and Gownden, but instead of censuring Mr. Ntelwa, despite realizing the unethical suggestion, the second indictment was drawn incorporating some of the amendments in accordance with the witnesses' statements to Ms. Serfontein. As set out earlier, the actions of Advocates Ntelwa, Gobadon and Gownden amounted to irregularities. Further consultations with other witnesses by Ms. Serfontein were cancelled without there being any reason for such cancellation. A probable inference is that Mr. Ntelwa did not want other witnesses to deviate from their police statements that could be exposed during such consultations. When Mr. Ntelwa was going to be replaced as prosecutor in the trial, Ms. Cheryl Zondi, the only complainant who had testified in the trial before Makaula J, wrote a letter to Ms. Batoy complaining about the decision that Mr. Ntelwa would be replaced. She also objected to Advocate Serfontein and included the names of witnesses in the matter who also petitioned against the assignment of Ms. Serfontein. This letter was forwarded to Mr. Sekata, the Acting Director of Public Prosecutions in Makhanda, for his comments. I have not been furnished with any comments he might have made, but it is after this that Mr. Ntelwa rejoined the prosecuting team. This was done while Mr. Ntelwa's superiors knew of the suggestion he made that the witnesses should be persuaded to stick to their police statements and thereby commit perjury. During the trial, Mr. Ntelwa, while one of the witnesses were being cross-examined during an adjournment, went into the witness room and spoke to the witness. He claimed that it was to comfort her. As he was an officer of court, such assurance was accepted. However, due to the lie he later told in court that I will refer to, I'm not sure that it was in fact innocent. If he did consult with the witness, it amounts to unethical behavior. See in this regard the Code of Professional Conduct and Ethics of the National Bar Council of South Africa, Rule 26.2. When Ms. Gianni's testimony commenced, it was not Mr. Ntelwa that led her evidence, but another prosecutor. It became obvious when cross-examination started why that was the position, for then the contradictory statement that she had made to Ms. Serfontein was disclosed. Ms. Serfontein had then, as an ethical prosecutor should, disclose to Mr. Doberman that the witness had made a contradictory statement to her. When I pertinently asked Mr. Ntelwa whether he knew that Ms. Gianni had made a contradictory statement, he denied that he knew that fact. The emails between the prosecutors were then disclosed to the defense after requested by the defense to do so. However, there were large portions of such emails that had been redacted and blocked out. When the unredacted emails were disclosed, it referred to further discrepancies between the statements of further witnesses and the consultations with Ms. Serfontein. The fact that there had been redactions is indicative of the attitude, despite what had been disclosed at that stage, that the prosecutors still did not play open cards with the court and the defense. These emails showed that the assurance that Mr. Ntelwa gave to the court that he did not know of the contradictory statements was false, for he was informed by Ms. Serfontein after her consultations at the same time that she informed his seniors. The defense brought an application for a mistrial where copious affidavits were filed. Mr. Ntelwa averred in one of such affidavits that he did not know that digital penetration of genitalia constituted rape. It is inconceivable that a prosecutor with 14 years' experience that is involved in a case where rape is one of the crimes accused one faced does not know what the definition of rape is. He was either extremely incompetent or dishonest when deposing to such an affidavit. Mr. Ntelwa also established a WhatsApp group where all the complainants were connected. When this was revealed, Advocate Garden, Mr. Ntelwa Sr., confronted Mr. Ntelwa about this. Mr. Ntelwa informed Advocate Garden that it was purely for logistical reasons. Instead of investigating this, all the WhatsApp messages were deleted. There had been an application to have this action of Mr. Ntelwa and the lack of action by Mr. Garden declared a special entry. I refused. However, it is a factor that should be considered when assessing the question whether the state has proved its case beyond reasonable doubt. The legal position. Burden of proof. The state must prove its case beyond reasonable doubt. There is no onus on the accused to prove his or her innocence or convince the court of the truthfulness of any explanation proffered. It is opposite to set out what such evaluation entails. In State v. V, 2001, SACR 453 SCA, paragraph 3, Zulman, J.A. set it out as follows. It is right that there is no obligation upon an accused person, where the state bears the onus, to convince the court. If his version is reasonably possibly true, He is entitled to his acquittal, even though his explanation is improbable. A court is not entitled to convict unless it is satisfied not only that the explanation is improbable, but that beyond any reasonable doubt it is false. It is permissible to look at the probabilities of the case to determine whether the accused version is reasonably possibly true, but whether one subjectively believes him is not the test. As pointed out in many judgments of this court and other courts, the test is whether there is a reasonable possibility that the accused evidence may be true. The oft-quoted case of Rex versus Difford, 1937, AD 370 at 373, it was set out as follows by Greenberg J. No onus rests on the accused to convince the court of any explanation which he gives. If he gives an explanation, even if that explanation is improbable, the court is not entitled to convict unless it is satisfied not only that the explanation is improbable, that beyond any reasonable doubt it is false. If there's any reasonable possibility of his explanation being true, then he's entitled to his acquittal. In Rex versus M, 1946 AD 1023 at 1027, Davies AJA said, the court does not have to believe the defense story. Still less does it have to believe it in all its details. It is sufficient if it thinks that there is a reasonable possibility that it may be substantially true. Furthermore, Brandt AJA said in State v. Shackle, 2001-2 SACR 185, SCA paragraph 30, that it is a trite principle that in criminal proceedings the prosecution must prove its case beyond reasonable doubt, and that a mere preponderance of probabilities is not enough. Equally trite is the observation that, in view of this standard of proof in a criminal case, a court does not have to be convinced that every detail of an accused version is true. If the accused version is reasonably possibly true in substance, the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected based on inherent improbabilities if it can be said to be so improbable that it cannot reasonably possibly be true. The cross-examination. Mr. Doberman, on behalf of the accused, argued that the cross-examination of the accused came to no cross-examination whatsoever. It is thus necessary to address the purpose and the consequences of such failure. The object of cross-examination has been defined in these words by Eric Morris, Technique in Litigation, page 134. It should be borne in mind that the objects of cross-examination are three, the first positive and the other two negative. They are to obtain evidence favorable to your client, to weaken evidence that has been given against your client, and finally, if nothing of value which is favorable can be obtained, to weaken or destroy the value of the evidence by attacking the credibility of the witness. In Principles of Evidence, 5th edition, Adjuta Stat E publication, chapter 18, paragraph 18.7.4, the following is said: a party has a duty to cross-examine on aspects which he disputes. The failure to cross-examine may in appropriate cases have evidential consequences in that an adverse inference may be drawn against that party. The duty to cross-examine on evidence that is in dispute exists so that the witness is afforded an opportunity to answer points supposedly unfavorable to them. Generally, the failure of the prosecutor to cross-examine an accused may be decisive and an acquittal will likely result. In State v. Busak, 2000, ZASCA 24, given on 12 May 2000, paragraph 51 and 52, the following was said: In context of the dispute now under discussion, that is the proof of the authenticity of the letters of 30 March 1988, but also in the wider context of the outcome of this appeal and the conduct of the defense in the trial court, it is clear that a cross-examination should put his defense on each and every aspect which he wishes to place an issue, explicitly and unambiguously, to the witness implicating his client. A criminal trial is not a game of catch as catch can, nor should it be turned into a forensic ambush. In this respect, we are in full agreement with the comments made by the Constitutional Court and President of the Republic of South Africa and others versus the South African Rugby Football Union, where the following was said: the institution of cross-examination not only constitutes a right, it also imposes certain obligations. As a general rule, it is essential when it is intended to suggest that the witness is not speaking the truth on a particular point to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, while still in the witness box, of giving any explanation open to the witness and of defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness's testimony is accepted as correct. One of the goals of cross-examination by the state is to obtain favorable facts, concessions, inconsistencies, and improbabilities. The importance of cross-examination is evident in the judgment of State versus van der Westhuizen, 2011, 2 SACR 28, SCA paragraph 11, where the following was said: in our practice, it is not the function of a prosecutor disinterestedly to place a hodgepodge of contradictory evidence before a court and then leave the court to make of it what it wills. On the contrary, it is the obligation of a prosecutor, but fairly and dispassionately, to construct and present a case from what appears to be credible evidence, and to challenge the evidence of the accused and other defense witnesses with a view to discrediting such evidence for the very purpose of obtaining a conviction. That is the essence of a prosecutor's functions in an adversarial system, and it is not peculiar to South Africa. The cross-examination of the accused was desultory in the extreme. No thought went into it. The trial was set down for 9 days to deal with the evidence of the defense. Accused 1 testified for a whole day, setting out his defense, but the cross-examination of accused 1 lasted less than a morning session. He was not cross-examined on his denial with reference to the complainant's testimonies. No attempt was made to elicit inconsistencies or improbabilities. His cross-examination consisted mainly of putting a very limited synopsis of the respected complainant's evidence to him, which evidence the accused denied, then putting it to him that what they testified about is correct. It is not that there had been little scope for cross-examination. There was ample evidence that the veracity of his evidence could have been tested against. The cross-examination was shallow and lacking the intention to uncover the truth. Similarly ineffectual and superficial was the cross-examination of accused 2 and 3 that amounted to no cross-examination at all. They did not deviate from their respective versions or contradicted themselves. In the instant matter, Mr. Doberman is correct that the questions asked by the prosecutors in the instant matter did not amount to cross-examination at all. Evaluation. In evaluating the evidence, it is incumbent on me to assess the evidence of the state and the accused to determine whether the state had proved its case beyond reasonable doubt. In doing so, I must keep in mind that the evidence of a single witness must be approached with caution. Furthermore, it would be wrong to say that I believe the complainants and therefore the accused defense must be rejected as false. Where there are 2 mutually destructive versions before the court, the matter must be approached as was set out in National Employers General Insurance Company Limited vs. Jaggers, 1984-4 SA 437E, where the court remarked as follows: "It seems to me, with respect, that in any civil case, as in any criminal case, the onus can ordinarily only be discharged by adducing credible evidence to support the case of the party on whom the onus rests. In a civil case, the onus is obviously not as heavy as in a criminal case, but nevertheless, where the onus rests on the plaintiff, where there are two mutually destructive stories, he can only succeed if he satisfies the court on a preponderance of probabilities that his version is true and accurate and therefore acceptable, and that the other version advanced by the defendant is therefore false or mistaken and falls to be rejected. In deciding whether that evidence is true or not, the court will weigh up and test the plaintiff's allegations against the general probabilities. The estimate of the credibility of a witness will therefore be inextricably bound up with consideration of the probabilities of the case, and if the balance of probabilities favor the plaintiff, then the court will accept his version as being probably true. If, however, the probabilities are even balanced in the sense that they do not favor the plaintiff's case any more than they do the defendant's, the plaintiff can only succeed if the court nevertheless believes him and is satisfied that his evidence is true and that the defendant's version is false. There are certain problems with the evidence of the complainants. No corroborating evidence was presented for the complainant's evidence. There must have been witnesses with regard to the first reports they made, which the state did not call. First reports do not prove that a victim was raped or sexually assaulted, but it does prove consistency and that it was not a recent fabrication. There would have been telephone records that could have corroborated the witnesses' evidence that they had to call or text accused daily or regularly. No such evidence was presented. If the evidence of the complainants is analyzed, it cannot be ignored that there is proof that some of them deviated from their police statements. The possibility cannot be ignored that Mr. Ntelwa had a much bigger influence on the witness's testimony, but the opportunity to test that had passed, as his attempted influence only came to the fore after they had testified, so there was no opportunity to cross-examine them on the possibility of the interference. Ms. Gianni, whose testimony was found not to be credible, was the person who indicated that she had laid a charge and that the police will contact the witnesses. It seems it was after this that the investigation into the conduct of the accused commenced. What casts a shadow over the evidence of the twins is that even after the arrest of accused one, the twins still publicly professed his innocence and danced in front of television cameras to show their support for him. They were not minors at the time. Sarah Mafikeng was 19 years old when she testified that she lied to accused that she was menstruating and was sent home. However, she returned to the mission house despite knowing what would be expected of her. Mr. Doberman is correct in his argument that it cannot be established what the influence of Mr. Ntelwa was on the evidence of the witnesses, as the suggestion by Mr. Ntelwa was not known at the time they testified. Mr. Caesar, on behalf of the state, argued that I should accept the similar fact evidence of the state witnesses. In State v. Nduna, 2010 ZASCA 120, the following was said in paragraph 17. It is settled law that while similar fact evidence is admissible to prove the identity of an accused person as the perpetrator of an offense, it cannot be used to prove the commission of the crime itself. This legal principle operates in addition to exclude such similar fact evidence from being confirmatory material on another count. However, the application of the rule is not to be confused with the situation where the rule is invoked to establish the cogency of the evidence of a systematic course of wrongful conduct in order to render it more probable that the offender committed each of the offences charged in respect of such conduct. The appellant's argument if it were to be accepted, would be tantamount to excluding evidence of the modus operandi of the appellant merely because he had been charged with more than one count of robbery. End of the quote. Witnesses in the instant matter were in contact with each other and discussed the case before charges were laid, but it was not disclosed to what extent. There's an additional problem that there had been a WhatsApp group where all the complainants were part of. Mazondi took the lead in complaining about the appointment of Advocate Serfontein as the prosecutor in the matter, proposing that Mr. Ntelwa remains. Furthermore, Mr. Ntelwa was the prosecutor who indicated that witnesses should be influenced to stick to their police statement. The case can be distinguished from the Nduna matter, where there were 2 robberies months apart with a similar modus operandi. The similar fact evidence cannot be taken into account in the instant matter in the light of the fair trial principle. The primary factor, unfortunately, is the lack of cross-examination of the accused. As indicated earlier, if there's no cross-examination on issues in dispute, it would be unfair to reject an accused's evidence if he or she has not had the opportunity to explain such issue. As the cross-examination of the accused was of such poor quality, it had the effect that the accused's evidence was not placed in dispute at all, and therefore it did not necessitate the calling of corroborative witnesses, if any, who might have bolstered their defense. A further factor that I have to take into account is the conduct of Mr. Ntelwa and the irregularities that his conduct precipitated. If he had been removed at the time the prosecuting authority intended to remove him, the outcome might have been different. Furthermore, I'm of the view that it is highly undesirable that the complainant can dictate who should prosecute in a trial, especially where a decision has been made to remove a prosecutor. I'm of the view that although there are aspects of the complainant's evidence that are unsatisfactory, I cannot find that their evidence is incredible. However, I cannot find that the evidence of the accused falls to be rejected as false either. This is especially so as the accused's evidence was not placed in dispute through proper cross-examination. When deciding whether the state has proved its case beyond reasonable doubt, this matter falls into the category where, in my view, the explanations of the accused are improbable, and I don't subjectively believe them. However, due to the uncertainty of the actions of the state and the lack of proper cross-examination, I cannot find that the accused's version are so improbable that they cannot reasonably possibly be true. The accused bore no onus to convince the court of their innocence. I am of the view, in the light of all the circumstances of the case, that the state has not proved its case beyond reasonable doubt.
Yes. Quiet, please.
The accused are found not guilty and are discharged on all the charges. The court will adjourn.
All right.
Man of God, how do you feel at the moment? It's been a long road.
I thank God. I thank God. I give him all praise. I am 67 by July, next July. I've been in prison for 8 years. For 8 years.
Are you looking to maybe, take action forward and seeing that you're not guilty and you've spent so many years?
I think it's better for me to rest first. I've been in prison for 8 years at this age. So I think we should give some time for that.
Pastor Sally, what's the first thing you want to do when you get out of prison after 8 years?
Only God can tell me. When it is time, God will speak to me.
And then anything else you would like to add?
Anything to add, please? Anything to add?
Anything else you want to add?